do actually have 3 questions. Yeah, so let's maybe start with it. The first question is quite long. I'm going to paraphrase as much as possible. I'm not sure who actually asked it either. But it's regarding a tenant moving into a pet-friendly complex. I'm assuming sectional title. It says block. Agrees to the rules to introduce his dog to all residents, which is a stipulation for pet approval. So there's a body corporate, I'm assuming. The body corporate has a rule that if you're going to tenant the block and you're going to have a dog, the dog has to be socialized with the other dogs. This guy agrees to it as a tenant. So I'm assuming the landlord probably has an agreement with him directly regarding this, maybe in the lease. But then he refuses. He refuses to socialize the dog. This causes havoc. The dog is walking past apartments unsocialized. There's been warnings. He continues to refuse. And now there's a lot of barking, which has never taken place before. So the first question seems to be, can the trustees give notice to this tenant to remove the pet, right? The second question that follows, so that's the first one, is what's the relationship? Does the body corporate have recourse against the tenant, against the landlord, around that kind of a range of questioning? The second question is, during this process of trustees trying to deal with the issue of the pets and the unsocialized dog, a third party, another owner, submits an application for a lodge dog, which the trustees reject pending the resolution of this current issue, dealing with the resultant disturbances to all residents due to the non-compliance of that initial pet owner, because introducing a new dog would not at this time be of any interest to all the residents. The third party does not accept this and wants to go legal, where the trustees in their right to refuse the application. So Nick, do you want to go for the first one?
Yeah, let me attack the first one. We'll try divvy it up between us. So I think what's important for people to remember, as you pointed out, I think this is a sectional scheme of some kind, which obviously allows pet ownership within the scheme. Okay. What's important to remember is that when you have a body corporate, a sectional scheme, there are certain rules that are implemented by that body corporate, okay, that relate to pet ownership. Okay, and majority of body corporates that we see, they're going to say something like you can't really own pets, but in certain circumstances where you've got a body corporate that perhaps has gardens which are attached to sections or whatever the case is, then they can allow pets. It just depends on the rules of the scheme. And what's really important when you do rules of a particular scheme is you need to think through what requirements are going to be necessary, in particular to that scheme, what kind of pets, what are the requirements for the particular pet. So in this question, they've said that the tenant agreed to the rules, okay, and then later on refused. Now, part of the thing here is when a tenant agrees to rent out a property within a sectional scheme, the landlord is in fact required to provide a copy of those rules with the lease agreement, because the tenant has to agree to abide by the rules as well. It's of no use if your landlord, who is the owner in the scheme, agrees to comply by the rules, but they put a tenant that says, I'm not going to listen to any of those things. That tenant has to agree to the scheme, the rules in that scheme, and they're supposed to be attached to the lease agreement in the circumstances. So the tenant is obliged to comply with the rules in the circumstances. And in this case, I'm assuming that the rules clearly stipulate that if you're going to bring a dog in, it needs to be approved by trustees, and the dog has to do certain things in the circumstances. Now, what makes this tricky in the circumstances is if this was, if this wasn't a tenant, the situation might be a bit simpler. But because there is a tenant, there are two relationships. There is obviously the body corporate, and they have a relationship with the owner of the section, okay? And then owner of the section has another relationship with the tenant. Okay, there is no relationship between the body corporate itself and the tenants in the circumstances, which makes things a little bit trickier. Okay, because any recourse that the body corporate has is not against the tenant directly. It is, in fact, against the owner of the scheme as a result of a failure to follow the rules in the circumstances. But to this question, the question was, can the body corporate give notice to remove the pet? Okay, like now, as I've said, the body corporate, in essence, couldn't give notice to the tenant to remove the pet because the tenant is not the direct party that's in contract with the body corporate. And remember, when it comes to body corporates, the underlying relationship between the parties is a contractual one. It's simply a contract between a body's corporate and the owner in the particular scheme. But what can be given in the circumstances is a notice to the owner of the scheme. So depending on the wording of your rules, okay, it seems clear to me that that the rules have not been followed in the circumstances because this tenant failed to introduce their dog to the other dogs within the scheme. Okay, now your rules should have some stipulations about what if that occurs. Okay, now general rules will have penalty provisions. I imagine these rules will as well. So if you don't follow the body corporate rules, we can levy penalties against your statement of account, and they should be set out clearly to say what those penalties are going to be in the circumstances. You're welcome to, you know, if they're set out there, and you go ahead and you issue your penalties. What they could do, okay, but it's a little bit tricky. You could issue a notice if your rules allow to say that the dog has to be removed. So the dog's not approved, and the rules make it clear that no dog could be on the premises unless they have gone through this process or complied with these particular rules. Okay, if that is the case and the rules do stipulate that, then you would be able to issue a notice to the owner of the property as the body corporate to say, the rules haven't been complied with, you need to remove the dog in the circumstances. Okay, and I know a lot of listeners, this is a hard thing to do, and especially if if you're going to try and enforce this, because there will be some level of enforcement that you can approach a court on to say, look, court, there's a contractual relationship. This owner has agreed that these are the conditions upon which a dog can be in the scheme. And if they haven't followed that, you basically approach the court and say, look, court, I want you to enforce the contractual agreement between the parties so that the dog is in fact removed. Okay, it's a very touchy situation, and I've had one or two circumstances where we have to do this for a client, and obviously it's a difficult circumstance. People take their pets very seriously, but ultimately there is a contractual relationship here which can be enforced by the body corporate if the rules haven't been followed. So can the body corporate give notice to remove the pet? Yes, in essence, as long as their scheme rules allow for it and the scheme rules haven't been followed in the circumstances, that notice could actually be given to the owner. All right, and then Bruno, I think I'll leave you then with the second question of the other owner who then brought in a dog, and it seems just didn't accept the fact that their application was rejected.
Yeah, look, so again, I think on Nick's point, it does come down to the body corporate rules. What we need to remember, and I think this is one of the problems, and I experienced this a lot in our commercial department, and you see the consequences when it comes to the litigation department, right? Is there's a reason why contracts exist. It's not a thing that lawyers have made up in order to try and make money from people, right? You might have never experienced a contractual dispute in your life, as an example, but the reality is we have, and all the ones that we have could be avoided by proper drafting, proper thinking. So yeah, you have those disputes where one person doesn't care what the contract says. And yes, in those instances, it's very difficult, like lending money to someone, they just don't pay you back. It's not a dispute, they're just not paying you back. But in certain circumstances, we find with contracts, it's the same when you set out rules and things like that, that the rules aren't drafted properly. So for example, if you have a rule that just says pets are allowed at the discretion of the trustees, it creates problems because South Africa as a society doesn't accept, and I mean, this is a personal opinion, doesn't accept discretion that well, right? We say the word discretion, but under discretion, there's bunches of like piece of legislation that govern how the discretion should be exercised. And by that point, it's not really a discretion anymore, to be honest, right? So if fiduciary responsibilities as an independent trustee, that where we have discretion, it's subject to so many different oversight mechanisms. So body corporates, going back to this, what does the rule say? Does the rule simply say, well, it's completely up to the trustees? If it does, immediately this owner is now going to be on the back foot, because he basically, the body corporate rules are broad enough to give the trustees whatever entitlement they want, right? Now, so that's already on the back foot. But then we start moving to obviously our conceptualization in South Africa of fairness. And is it fair to discriminate? Is it fair to do one thing for one person, not for the other person, right? Very similar to the way our labor law works, our tenancy law, that sort of thing. So now this owner goes in and says, but hold on, guys. Number one, you've set a precedent that certain things are allowed. So you've exercised your discretion in a particular way a number of times, and you're not giving us proper reasons why it can't be exercised in any differently now. And remember, we've got CSOS now. So again, we start looking at things like fairness. We start looking at the proper treatment of people. We start looking at majority versus minority and the protection of minority. Minority is in like actual owners. So if you have you're one person that owns 60% of the block, it doesn't mean that the 40% will just be outvoted each and every time. So because of this, to answer the question is virtually impossible, because we'd have to look at the rules, we'd have to look at the justification. So recently there's been a case law that actually came out regarding the Airbnbs in certain sectional schemes and whether that's permissible or not. And the argument was all over the place. You had different opinions where some people were going, well, they can't just change the rules and now I'm not allowed to have an Airbnb. I bought it for an Airbnb. How dare they? And we even went so far as to say, well, there's a valid argument to say that unless they actually give a good reason, that shouldn't be allowed. And I actually stick by that argument. But in this court case, it was the other side of it where they said, well, you know what, people want to live in an estate that functions in a certain way. Short-term letting creates a different functioning of the estate. So if that's what people bought into, that's what they bought into, people can't come now and fight it. And the court upheld that. Whether it's going to be appealed or not, different story. So going back to the dog question, do the trustees have proper reasoning for making the decision that they have? Maybe they do, depending on the wording, depending on the level of discretion that's been given to them, depending on setting the precedent and the logic behind their decision making. Maybe they do, maybe they don't. I'd go on a whim and say, introducing a new dog, but let's say there's 100 dogs, it's one unsocialized dog, and now they're refusing one person their dog because of that other one, but there's still another 99 barking. I don't know whether one extra dog is going to make all that big a difference. I'd probably go so far as to say they should have probably made this known beforehand to say, sorry, we're stopping until this guy sorts himself out. But then again, there is no right or wrong answer. Does the third party, if the third party wants to go legal, I would suggest trying to approach CSOS and seeing what happens. But yeah, I would probably say this is like a 50-50. It could really go either way.
Yeah, I agree. It really does depend on the facts in the circumstances and how their reasoning came through.
Yeah. The reality is the owner would be on the back foot if the discretion sits with the trustee. So he just needs to realize in law we speak about onus. So I normally look at it as the person that needs to make that first step. And in this case, if the discretion sits with the trustees, the owner is going to need to be the one that goes in saying, but you're being unfair, as opposed to the other way around. So that's the only real answer I can give in these circumstances.
Yeah,